Sometimes sentences here at the New South Wales Local Court are reduced because the defendant successfully argued extenuating circumstances. In my opinion, I'm not sure we, the community, knowing what the sentence was in the end, is really that beneficial, because the sentence was tailored for that particular defendant with those particular circumstances. The rest of us really shouldn't expect the same sentence unless we are that particular person, which we're not. Rather, I think the community would benefit more from knowing how the court followed the law when reducing the sentence. So let's still talk about the case, but not focus on the amount that the fine was in the end or the length of the corrections order. Instead, did the court follow the law? Did they base their decision on valid reasons? Here are two examples from June 2025 at Kurri Kurri Local Court. Both cases are speeding and are unrelated. Both drivers are unrepresented and therefore present evidence and make arguments without the assistance of a solicitor. We are told the first driver has a poor driving record. They were caught speeding 2 days before their good behaviour licence was due to expire. The driver explains that they had just been told their child was injured and was rushing to get to their location. A lot of paperwork is being passed up to the magistrate. The magistrate accepts the extenuating circumstances. There were many words spoken about road safety. The driver still received a sentence. However, I'm not going to say what it was because it was given specifically for that particular driver. The second driver is more mature aged, and we hear they first got their licence in 1977. Their driving history includes 31 speeding offences. And we hear this is their third offence for excessive speed between 30 and 45 kilometres over the speed limit. The driver and the magistrate discuss the need for a licence for medical appointments, but the driver is particularly worried that losing their licence will mean they'll lose their job. The job is said out loud in open court. It's related to a school. So with a poor history and another excessive speeding offence, the likelihood of being disqualified is high. By the way, like the first driver, there was many words said about disobeying road rules and the need for safety. In the end, the driver is disqualified, but they don't lose their job. How, you ask? Well, you had to listen closely to the dates of the disqualification, as they were particular days in July. I'll give you a clue. Remember, the driver's employment relates to a school. What happens in July in New South Wales? School holidays.